Frozen for just 1 second. Hold on. It froze. Right, here we go. Frozen for 1 second. Hold on, sorry. Here we go. All right, wouldn't let me go out of it. Okay. Here we go. Okay, so welcome everybody. As Melody mentioned, this is the day one of a great 3-day event that we're going to be putting together. So day one, as we mentioned, we're going to have our legal expert, Kara Wolf from McCarter English, and we're going to introduce her in a few moments. Day two that we have coming up, we're going to be having a representative from CISA. The cybersecurity is going to cybersecurity and security at the from Homeland Security are going to be talking about small business perspective. And so it's Mike Tetro is going to be talking tomorrow. And day three, we're going to spend basically the whole session talking about CMMC. And from a practitioner perspective, how do you put it in place? What are the things you know? What are the things you might not know? And what are those some tricks and that you might be able to use in your particular situation? Yes. So really what we're all three of us are all three different groups have been working together on this presentation and this set of series of items that we're going to be talking about. First we have the Southeastern PA, as you mentioned, by Natasha Boshanin, and also the Rhode Island PTAC, which co-hosts is Melody Weeks. And we also, obviously, ourselves are 3 compliant. We're our registered provider organization based both in Rhode Island and also in Southeastern Pennsylvania. So just for some quick session housekeeping, everyone is going to be muted by default. So if you have any questions, you can ask them in the chat as we go along, and we're going to try to answer those as we go along. There will be opportunities to ask other questions too, and we'll make sure that we address those before the end. There is going to be a few anonymous participant polls that are going to be used. There's going to be ones done at the beginning and towards the end of the presentations today. And hopefully you get some of those results. You're going to be able to see some things, and hopefully you're going to draw some information for yourselves and also for how you're going to approach your stance for CMMC. There's also going to be other Q&A sessions, and there's going to be ways to contact the experts, and there's also free resources that we will be making available to the teams here that are on the call, and we'll make those available as well. So the first thing we're going to start off with is a little participation poll from, we're just going to, hopefully that'll pop up in a second. And so if you could take a minute to just fill out the first question about where are you on the CMMC journey? And hopefully that gave everybody a chance to fill that out. And we have the results. Here we go. So 67% of the people are already on the journey, which is really great. 17% are planning to be. That's fantastic. Obviously, you're moving in the right direction, and you're not sure. That's okay too. Hopefully, we're going to be able to provide an awful lot of information over the next 3 days that will help you get on that journey. So that's great. So one of the things that we just want to talk about just is in a very high level, and this is just putting things, looking at this from a 10,000 foot view, has to do with some of the timelines. And why these are important is that there are rules that are coming into play. There's going to be, right now there's some DFARS rulemaking is going to set the CMMC requirements more or less in stone. And those are going to be happening over the next several months. So there's supposed to be, the schedule does change. But right now they're trying to have this preliminary rule out by March. They're going to put the preliminary rule in effect in somewhere in May, and then then there's going to be looking to enforcement of the new rule. However, they will allow some time to roll out over time. It's going to be advantageous for companies by the time May roll around to be able to be in a good stance for CMMC, because other companies will also obviously be preparing. Those companies that are more advanced than where they're supposed to be, it's going to be a great advantage. And actually, it might even be a business opportunity for them, for their competitors that they might be competing for those particular contracts. So this is just a quick one-page overview for CMMC. We are going to go into this stuff in depth ad nauseum on day 3. But this is just really to lay out some really, high-level concepts about what we're talking about here. Really, there's a few different things. If you heard some terms called FCI, CUI, and CTI. FCI has to do with federal contract information. CUI is controlled unclassified information, and CTI is a type of CUI called controlled technical information. So that might be things such as drawings, diagrams, other information that might have come into play as a product of things that you do. There are some things that also are into play here. NIST 800-171 is the primary document in the background that controls most of those items in terms of the controls that need to be in place to protect CUI. There's different levels and there's different things in which you may or may not need to comply with based upon what CMMC level that you're dealing with, but NIST 800-171 is that governing document. There are CMMC specific guides and documentations based upon the levels that you have to prescribe to. And there is something called the Cyber AB, which we're going to go into detail on Thursday about. This is the group that's in charge of approving all of the registered provider organizations and also the C3PAO organizations, which those are the organizations that do the assessments that will actually grant you that approval to say that you are, for example, CMMC level 2 certified. There's also something that's coming, that's also a topic that will be talked about over the next few days, and that is the Supplier Performance Rating System, or SPRS. This is something that just about all providers will need to, if they haven't already, need to go in and attest to. This is a different requirement than CMMC itself, even though it is related. You're making an attestation, and regardless of whether you're doing CMMC level 1 or 2, it doesn't matter. It's a separate attestation, and you're going in and you're declaring those. And those things have been in place for several years now. I'm sure that those are going to be brought about in the conversations that you're going to hear later on this morning. One other item quickly too is that there are currently 3 levels. Most organizations will wind up only having, at least they're predicting, will have federal contract information, which will leave them at a requirement for level 1. And those are 17 practices, and they're allowing an annual self-assessment. Level 2, those are organizations that are handling either CUI or CTI. Those are going to require all 110 items from NIST 800-171. And also, they are going to be required to do third-party assessments. So that is where a little bit more of the rubber meets the road. There's a significant difference in the amount of things that you need to prepare for, and also the assessment activities that will happen for level 2. there's a good decent amount of folks will wind up falling into that level 2 category. There is a level 3 category. This is something that you will wind up only being in if the DoD tells you that you are. These are going to be more specialized areas. And in addition to 171, you're going to have to do some of the requirement. You're going to do, I think, all of the requirements in 172 as well. So they haven't come out with the CMMC level 3 information as of yet, but those also will require assessments, but this is more involved than level 2. And the bottom line is going to be a very small group of people that will fall into that category. So with that being said, I'm going to be introducing in a moment here, Kara Wolf. And Kara is a partner at the law firm McCarter & English. She focuses her practices on government contracts and regulations. She has extensive experience counseling clients regarding compliance with federal, state, and local public procurement requirements. She also assists in litigation involving bid protests, claims, and other disputes before federal agencies, courts, and the U.S. Government Accountability Office, otherwise known as the GAO. And Kara is a frequent lecturer at cybersecurity regulations and executive orders as they apply to U.S. government supply chain. And with that, hold on a second, sorry. Kara, if you want to. Should be able to stop share.
Okay, thanks very much, Bill. Good morning, everyone. Thank you for joining us this morning. Let me just see here. I'm gonna get my PowerPoint up so we've got that for all of you. Okay, hopefully you can all see that. All right, so good morning again. As Bill said, my name is Kara Wolf. I am a partner at McCarter & English. A little bit about our firm. We are a full service law firm. We do, everything under the sun. We've got offices up and down the East Coast, from as far north as Boston and Washington D.C., where I'm based, and then a lot of offices in between. Many in Connecticut, New Jersey, New York, Delaware, all the way down. We also recently opened offices in Miami and Indianapolis, so we're growing across the country, and happy to talk with any of you about any of the issues you might be facing in any practice area. But my area specifically is government contracts work. Prior to joining McCarter, I worked for the Department of Defense. I worked for the Army Corps of Engineers, and then the Defense Contract Management Agency up in Boston after that. And so I've been with McCarter for about 5 years now. And I do a lot of this type of work. So I've been increasingly focusing my practice on these cybersecurity requirements in the past 5 years, because they have been and continue to be a point of focus for agencies, and particularly the Department of Defense, when they're determining how to award contracts, to whom to award contracts, when they're administering their contracts, and so on. So I'm going to be spending the next 30 to 45 minutes kind of going through some of the DFAR cybersecurity requirements that hopefully many of you are familiar with. And to those that aren't, I'm happy to go in more depth on any of these topics if you have any questions. And then I want to talk a little bit about the False Claims Act, which is a law that gives the government the ability to pursue civil and criminal penalties against individuals and contractors who make false claims to the government, as the name suggests, right? We'll talk a little bit about what the standard is for that and what the government's ability to recover money and also potential criminal penalties is, and how that relates to cybersecurity. Well, the Department of Justice in October of 2021 started a civil cyber fraud initiative. And so, recently they've been pursuing these types of cases related to false certifications of compliance with cybersecurity requirements. And that has caused, and we'll talk a little bit more details as we get to that section, millions of dollars in settlement that has been making the news. And what we're seeing is a trend, not going anywhere anytime soon, especially as we start to see the CMMC requirements start to develop. This will be more and more relevant as we go on. So with that, I'll just give a little bit of a introduction to cybersecurity, which I assume most of you are pretty familiar with the concept, but we'll just frame it a little bit before we launch into the basics of the 3 DFARS clauses I'm going to cover today. Hopefully, most of you are familiar with these at this point. DFARS 252, 204, 7012 has been around for 6 or so years at this point, I think. And then 7019, 7020 are, as Bill mentioned, the STRS certification requirements. It's assessment requirements that we'll talk about what those are and what those look like when you see them in your contracts. And then I'll talk about the consequences for noncompliance, which, as I mentioned, is primarily through the False Claims Act. But of course, the government has any number of ways that it can pursue non-compliant contractors, whether that's through contract action, termination for default, suspension and debarment, all the way up through judicial action. So we will cover all of that and sort of frame why it's important to be compliant with these, to understand and be compliant with these requirements. Just a little disclaimer here at the bottom. This is just I am a lawyer. I practice in this area, but this presentation is not legal advice. This is just my views, and it's not representative of anybody else on these topics. So just a little, wouldn't be a presentation from a lawyer without a disclaimer. So with that said, we'll jump right into what cybersecurity is and why it's important. It's been defined a bunch of different ways. We like this definition because it covers really all the basics: the activity or process, ability or capability or state whereby information and communication systems and the information contained therein are protected from and or defended against. And these 3 basic areas: damage, unauthorized use or modification, or exploitation. So, those are really the 3 things that we're trying to protect against. There are 3 objectives in cybersecurity that pretty much captures what it is that we're trying to do. And we have these cybersecurity requirements applicable to your contracts. So what is cybersecurity not? And I'll use the words compliance, and I'm going to probably contradict myself here, but I think a lot of times when we think about compliance work, and I do a lot of compliance work, we're thinking about, okay, I've put the policy in place, I can check that box, I can move on. When we're talking about cybersecurity, it's not something that's as easily dismissed. You have certainly a set of requirements that you have to meet, and you need to be sure that you're complying with those. But understanding that the bad actors are rapidly developing their skills, and so cybersecurity, for its part, has to be something that is dynamic as well. It's not static because the threats are not static. So, when we talk about cybersecurity, it's really an ongoing process that companies need to take seriously and incorporate as part of their operating procedures. It's not easy, it's not risk-free, and it's not cheap. It's something that is worth investing in as a company, because the costs for noncompliances, we'll talk about the False Claims Act at the end of the presentation, but certainly there are other costs to cyber attacks and cyber breaches that I'll talk about here in just a moment. Why it matters: since 2020, when we all started working from our respective home offices, we saw a dramatic increase in cyber crimes. And here's just a few examples from the first half of 2020. And of course, there's been hundreds, if not thousands, more attacks since then. But these are big name companies. These are including the government, of course, but big companies and state agencies and all kinds of different companies and entities of all shapes and sizes have been victims of cybercrime. I just saw this morning, there was a Russian, or attributed to Russian intelligence, ransomware attack on Polish and Ukrainian transportation and logistics companies. So we see a lot of, politically motivated cyber attacks. We're seeing a lot of cyber attacks in the war on Ukraine. That's just one example of how this is a routine part of operating in this cyber world. So we've seen all kinds of cyber attacks, and this is certainly, you don't want to see your company's name on this list next time I give this presentation, because we have just a plethora of examples of how these types of issues can balloon into some real harm. including things like, releasing your customer data, your personally identifiable, their personal identifiable information. I don't know how many of you have, well, I suppose I should say, how many letters have you gotten from, or emails from companies that you've done business with, either as an individual or as an entity, where you've had to, you've had them explain to you, look, your customer data was exposed, change your password, here's your credit monitoring services, all that kind of stuff. That's all related to cybersecurity breaches. And so, you definitely don't want to be in the position of having to alert your customers that their name, address, social security number, medical information, financial information, whatever it is you're holding, has been released to whoever, the internet. Your intellectual property, including your trade secrets, can be the spoils of a cyber attack, right? If you've got a particular process or schematic that is proprietary to you, and a cyber criminal is able to get their hands on that, and then it's out there, and that can have real competitive harm for you as you're trying to continue to grow your businesses. And of course, your organizational financial data, anything like that, that can be released. So it's a lot of sensitive data that you don't want to have out in the universe. And so, these are the kinds of, and again, this is not just specific to government contracts. This is also, just any kind of cyber attack that will impact your business. Of course, we're going to focus in on what it means in the government contracting context, but just wanted to set the scene here as far as why you should be very, very concerned. And obviously, all of you are, because you're here at this presentation, why you should be concerned about your cybersecurity requirements, because again, you can do financial loss, brand damage, embarrassment, data leak and breach, IP loss, identity theft, liability risk, all the things I just alluded to. And what's not on this list, and what we're going to talk about for the rest of the presentation, is the impact to your government contract business. So with that, we'll jump into how the Department of Defense addresses these cybersecurity threats, and what clauses are in your contracts. And I'm almost certain if you have a Department of Defense contract, you have these clauses in your contract, how the Department of Defense is addressing these cybersecurity threats. So the first, as I mentioned, is DFARS 252, 204, 7012. Hopefully most of you are very familiar with this clause. It covers two different scenarios. Most of the time we see IT systems that are contractor owned that are affected by this clause. If you're operating an IT system on behalf of the government, that's got a slightly different set of requirements attached to it. I'm going to focus mostly on the contractor owned system, which is significant, right? Because it's not so much related to the product or service that you're delivering to the government. If you're not delivering them an IT system, you could be a construction contractor or, supplier or something that you would normally not associate with computer systems. These requirements are still going to apply to you as a business, if you want to be doing business in the government space, right? So the main requirement here is expressed in subsection B, and it's a really deceptively simple looking requirement, in that it says the contractor shall provide all adequate security on all covered contractor information systems. But when you actually break that definition down into its component parts, you see that the actual requirement is pretty intricate. So, here we've just plugged in all of the definitions to kind of expand what is that adequate security requirement actually requiring of you. So again, we see those three pillars of cybersecurity. Again, loss, misuse, or unauthorized modification of information. You're trying to provide the protective measures commensurate with the consequences and probability of those three risks, right? And it's going to, some of the categories that Bill mentioned are built into this definition: controlled and classified information, technical data, controlled technical data. It really becomes a very deep requirement that requires some pretty clear understanding of what is in your information system, what controls you have in place to protect what is in your information system, and what information you're receiving from the government that might need to be protected as well. So the way that this works in practice is that your IT system, your contractor owned IT system, is going to be subject to the requirements in NIST SP 800-171, which is protecting controlled and classified information in your non-federal information systems and organizations. That's a publication put out by the National Institute of Standards and Technology, NIST. You'll see updates to it periodically. It's really the core requirement of cybersecurity, and as Bill already alluded to, it's going to be a significant part of your CMMC compliance when you actually get to that point. Part of it is going to be, are you compliant with all of the NIST SP 800-171 requirements for, depending on which level you're going to be at. And you should already be, because this clause has been in your contract for the last few years. Contractors have been required to comply with all of the 800-171 requirements already. So hopefully you are all already well on that path. But to the extent that that requires some additional legwork at this point, now would be the time to do that, so that you're not running the risk of any False Claims Act allegations, which I'll talk about, and any, as you continue on, as you need to be CMMC certified, what is that going to look like as far as your NIST SP 800-171 compliance? So just kind of very briefly, what's in NIST SP 800-171? These are the security requirements when you've got controlled unclassified information in your system and your organization, right? If it's, it's focused on the contractor systems, and it includes categories, things like access control, who has the ability to get to the information, how are they getting to the information? That can include things like physical site security, and who's got, the permissions to access certain files, that sort of thing. There's what is it? 1, 2, 3, 4, 6, 7, 8, 14 categories here of requirements that are going to be applicable to your system. And as we'll see in a moment, you're going to be needing to assess your compliance with those requirements as we go forward. At this point, in this clause, 800, not 871, in 252, 204, 7012, you're required to comply with these requirements, right? And as we'll see in a moment, there's a reporting requirement to the government should you have a cyber incident. And those are really the core parts of the 7012 clause. And as we'll see in a moment, now the DoD has begun requiring and is incorporating in contracts clauses requiring assessments to I call it the trust but verify clauses, where the government is now requiring you to go through and verify that you've complied with all of these requirements and submit that assessment on your supplier performance risk assessment profile to indicate to the government where you stand as far as your cybersecurity compliance. So again, this is just the kind of introduction to the 800 words. And I don't know if you all have access to the slides or not. I'm happy to share them with anybody. I don't know if they're going to send them out to you all after the presentation or not, but if anybody would like a copy of these, I'm happy to provide them. My contact information is at the end. I'll put it in the chat too when I pause my presentation. But the this is just the function of 800-171. The publication has all the requirements in it addressing the control and classified information. If you have classified information, that's a separate issue. If you're not handling CUI, you don't really need to worry about this, but most of the time, if you're in the federal contracting space, especially in the defense contracting space, you're probably going to touch CUI at some point, or have it transiting through your information system at some point. So again, this is just the kind of disclaimer in 800-171. We talked about the 3 pillars of cybersecurity. Again, they're also referred to as confidentiality, integrity, and availability. 800-171 primarily addresses the confidentiality security objective. Integrity and availability are a little bit of a different animal. But there's a very detailed set of requirements that are in this publication that are going to be required, but just know that this is just one piece of the cybersecurity pie when you're putting together your compliance structures as compliant with all of these requirements. So again, things that are not in 800-171. So again, I guess my main point here is that 800-171 is a floor, it's not a ceiling of cybersecurity compliance requirements. You know, this actually has some gaps in it on 800-171 because it assumes you already have the information security policies and procedures in place addressing all of the cyber requirements in those 14 categories that were on a few slides ago. You know, it assumes that you already have a system in place to create and maintain these records. You have an incident response plan. You know, you have any kind of codes of conduct that address cybersecurity and penalties for failing to abide. You know, that is one of the most critical pieces of this, at least from my perspective, is making sure that you have codes of conduct and procedures and policies in place to make sure that you have educated your workforce as to what the cybersecurity requirements are, and what is necessary to comply with those requirements. And you know, cybersecurity breaches have a very, and I don't have enough time today to go into the full details of how 7012 gets implemented, but there is a rapid reporting requirement in there that you have to report to the DoD within 72 hours of discovery of a cyber incident, which is, depending on who you talk to, it's not a whole lot of time. Some people think it's a lot of time, but I mean, it depends on your perspective, how quickly how quickly bad actors can work. 72 hours can give them a lot of time to do things in the system that they shouldn't have access to. But from a business, operations perspective, it's not a lot of time. If it inevitably happens at 5 p.m. on a Friday, right? So, it's always something that has to be front of mind, and has to be rapidly responded to. You have to have those procedures in place to say, okay, we know an incident happened. We need to be able to identify quickly what was accessed, who, what was compromised, if anything, and then what the impact is, what's the damage, what were we able to do to mitigate any kind of attack. All those kinds of investigation pieces need to be in place so that you can comply with that rapid reporting requirement in your 7012 clause. And again, as I said, the 800-171 doesn't address the objectives of integrity and availability. So things like, changes to the data, inadvertent deletion, the accuracy, validity of the data. Did somebody go in and change something that shouldn't have been changed? Backup, ransomware, distributed denial of service attacks is not something that's covered in 800-171. So as I mentioned, there's the reporting requirements in 7012. Again, rapid reporting means 72 hours from discovery of a cyber incident. These are as I mentioned, these are the required elements. So you have to be able to have in place the ability to provide this information within the 72 hours. So, especially here towards the end, you're talking about things like what type of compromise was it, what was involved, what was the technique or the method used in the incident, what's the outcome, and then a narrative and any additional information of what happened. So again, having that compliance structure in place where you have your workforce on alert that they need to report these kinds of incidents, and then having the cybersecurity structure in place so that you are able to rapidly report the information when you receive it. Okay, so that's the very quick high-level overview of the safeguarding covered contractor information requirements found in SP 800-171. And the clause, again, 7012 clause requires compliance with those requirements. But until these 7019, 7020 clauses came out in 2020, I believe, there wasn't any mechanism for the government really to verify that the contractor was compliant with those requirements. So what this does here, these clauses here, what they essentially do is they turn NIST 800-171 compliance into a go, no-go decision for contracting officers. 252, 204, 7019 requires offers to have a current 800-171 DoD assessment on record in order to be considered for award. It requires it to be posted in SPRS, and it requires, your subcontractors need to have this as well. If you're going to be working with a smaller company or a different company that's going to have the control and classified information in their systems, you're going to need to make sure that they're compliant with these requirements as well. 7020 is, again, the assessment requirements requiring the contractor to provide the government access when necessary for DoD to conduct their own or renew any kind of higher level assessment. And again, requiring applicable subcontractors to have the assessment themselves posted in SPRS for the review of the government. And so now I'm going to talk really quickly about, what does it look like when we're talking about what do these assessments look like? What do they consist of? And the publication has a companion, basically 800-171A, that gives you the details about how these assessments are to be conducted, what are the procedures, what's the methodology that you can use to conduct these assessments required. You can customize it as you need to, and as and we'll see in a moment, who's conducting the assessment will dictate a lot of what is required and how you are to be conducting these assessments. They can be done as a self-assessment, third party, or government sponsored. Again, depending on who's conducting the assessment, it's going to be different levels of complexity and different levels of intensity. The idea here is to facilitate your risk-based decisions by organization related to your CUI requirements. So this is just a sample of how the scoring template looks. So, you start, the way that they score is you start with a score of 110, and then, any non-compliances are subtracted from that number. You could even go into the negatives, which is obviously not a great situation, but essentially, the requirements are going to be weighted based on their impact to security. So here's a good sample of a template. You've got a security requirement here, limiting access. So this is an access control requirement, right? And it's weighted based on the risk associated with non-compliance with that requirement. So you see there's a couple here that have a value of 5 points, a couple here that have a value of 1. And so you're going to need to go in and verify, whether you have that security requirement in place. There's not going to be any credit for POAMs. If you're still working on a plan of action to bring yourself into compliance, you don't get partial credit for that. You're either compliant or you're not. And that's going to be, that's going to have an impact on your final score. So again, this is just sort of a overview of the assessment level and what the confidence level is resulting from those assessments, depending on who's conducting them. Again, you can do it yourself. You could have your contractor personnel trained. You could do it with a third party. You could have DoD or DCMA personnel who are trained to come in and conduct the assessment. And then, the various things are going, the assessments are going to consist of different things. If you've got somebody coming in from outside, there may be interviews involved when they go in and assess all of your cybersecurity procedures to see if they're compliant with the 800-171 requirements. And then, the scoring methodology is going to be consistent, but the confidence level is obviously going to vary based on who's conducting the assessment. So if you're doing a self-assessment, that's going to be the lowest confidence level. And then as you go up the chain and you have somebody external conducting the assessment, or the Department of Defense itself conducting the assessment, that's going to increase the confidence level in the results. So Bill mentioned it, I've mentioned now a couple times, the supplier performance risk system. Just, for those of you that are unfamiliar with that system, that is basically the DoD's application to pull supplier performance information. So it basically displays all of the information about the data about the performance of suppliers, your past performance, and your associated risk score. So, and that's where they're going to host the assessment results, right? Because it's going to have an impact on the government's assessment of you as a contractor and the risk of providing, information and funds to you as a contractor. That's now going to be wrapped up in your cybersecurity compliance. These are going to be these assessments are going to be valid for 3 years, so they're going to need to be reassessed triannually to make sure, if you've got some deficiencies, that gives you time to correct them. Also, as I said at the beginning, it's not necessarily going to be a static set of requirements. As the threats evolve, the requirements to have adequate security to protect against those threats is also going to evolve. So you're going to want to make sure that you're looking at the evolution of the requirements and making sure that you're compliant with all of those. Okay, so that was the rapid trip through the main DFAR cybersecurity clauses. Again, we didn't have time to go into a ton of detail about the nitty gritty of all these requirements in the NIST 800-171 requirements. Hopefully you're familiar with many of them, and I think you'll probably go over them in some more detail over the course of this series. But what I really want to focus on here for the rest of our time together is the consequences for non-compliance with these obligations. Now you've got contracts that have dozens, if not hundreds of contract requirements in there, right? Dozens of FAR and DFARS requirements, or depending on what agency you're working with, you could have other acquisition regulation clauses in there as well. And when you're submitting your invoices to the government, something called the implied false certification theory, when you're submitting your invoices to the government, you're impliedly certifying that you are compliant with all contract requirements, right? Sometimes you're expressly certifying that you're compliant with all contract requirements. You have a certification that the government makes you sign. But what that basically does is prompt the government to pay you, right? Based on you saying, I'm compliant with all contract requirements. And if that's untrue, then you could find yourself in a position of being subject to a False Claims Act requirements. False Claims Act allegations, I should say. And that is something that has severe financial consequences, reputational consequences at a minimum. Even though we'll talk about some of the big settlements that we've seen recently, but and settlements are interesting because they're not an admission of liability, right? They're expressly not admitting liability. They are the government saying, okay, well, we came to an agreement, so we don't have to continue litigating this case. No one's saying you did anything. No one's saying you didn't do anything. We're just gonna close the book on this and move on. But that, in and of itself, to get to that point, in and of itself, requires you to go through a pretty extensive litigation process to deal with the consequences of a False Claims Act allegation. Excuse me. So, even at that, you don't want to be in the position of having to call me or other counsel to try to defend you against these allegations, only to come to the end where you have to pay millions of dollars to resolve these allegations. So all of which is to say, it's very, an ounce of prevention was worth whatever how much of cure, right? To have these compliance structures in place, to understand your cybersecurity obligations and make sure that you are compliant with them, so there isn't any room for anybody to claim that you have violated the False Claims Act. And it's not just me saying that. Even as recently as June of this year, there's a memo on cybersecurity that the Defense Pricing and Contracting Office put out, basically, quote unquote, reminding contracting officers who already are aware of this, that non-compliance with the 7012 requirements is a material breach of contract, or can be a material breach of contract. And that can entitle the government to take all kinds of correct, of action there. They could withhold the progress payments. They could choose not to exercise contract options. They could even terminate the contracts. And this is kind of addressing the gap between, as I mentioned, the 7020 assessment requirements, which have been out there for a little while now. I'm starting to see them in contracts more often. For a period of time, they weren't. In that gap between when 7012 came out and when 7020 came out, there was a period of time where they didn't have that verification requirement. But this is basically Department of Defense reminding itself that, even if we don't have that assessment and access requirement in your contract, there are other ways to deal with cybersecurity noncompliance. So I include this as sort of the precursor to some of the more severe False Claims Act requirements, just to emphasize the point that you could still have negative contract actions for noncompliance with you, even if you don't end up embroiled in a False Claims Act allegation, in a suit with the Department of Justice. That's still a noncompliance with your contract, right? You could still have all of the contract remedies that come into play when you're dealing with contract noncompliance. If you aren't compliant with the cybersecurity requirements. So I mentioned that just so we don't lose sight of that. But the False Claims Act is really, kind of the big bad as far as non-compliance with these requirements goes. The False Claims Act actually came into being around the time of the Civil War to prevent defrauding of the federal government. When there were suppliers of the things that the Army needed to fight the war, that was when Congress realized that they needed to have some sort of protections in place to make sure that those prices weren't being inflated and that the requirements that were needed were being met. And I love the historical focus on I love looking at the history of these things sometimes, because it all kind of clicks and makes sense why that requirement's in place, at least for me. That's one of those areas. So again, intended to prevent defrauding of the federal government, and the violations here are knowingly presenting or causing to be presented a false or fraudulent claim for payment or approval. So again, anytime that you are presenting something to the government with the intent of getting the government to pay you, that is something that could be the basis of a False Claims Act suit if that claim or statement is untrue. Or, as I said, if you're certifying compliance with all contract requirements, even if you're not specifically saying, I hereby certify that I'm compliant with all cybersecurity requirements, you could still find yourself in a situation where the government can legitimately argue that you have violated the False Claims Act by claiming to be compliant with all contract requirements. So that is sort of the function here. And it's not, we talk about knowingly, and I'll get a little bit more in depth as what that means at the end. But I mean, a lot of times these types of things they sneak up on you by not having the right compliance systems in place. And we'll talk about that in just a second. Before I get to that, let me just point out the fact that this can be, especially for smaller contractors, this could be an existential threat. This could be a business ender, right? The financial penalties are substantial. Triple damages and per claim penalties for every certification and claim for payments submitted to the government. So, you submit a fraudulent invoice for $100,000, automatically the government gets 3 times that in damages, right? $300,000. And per claim penalties. So those are somewhere in the neighborhood of between 12 and 25,000. I don't have the exact numbers in front of me, but it's a significant amount of money for every invoice or every false claim that's been submitted to the government. So, your false claim for $100,000 is now 300,000 plus, let's say 25,000, 325,000 is what you owe the government. And then say you submit that $100,000 invoice monthly for 4 years before the government realizes that you've been submitting false claims. There you go. Like, that's just a mind-boggling amount of money, at least for me. I suppose it's not that, mind-boggling maybe to some, but it is a significant amount of money, well beyond whatever you were able to, the ill-gotten gains you got from the false claim. This can be the end for a company that doesn't have, a good compliance structure in place to make sure that there aren't any False Claims Act allegations. Because again, even if you end up in the settlement stage, you have substantial legal risk to even get to that point, to fight even a questionable False Claims Act action, right? You're paying, me or somebody else to go in and fight on your behalf to try to defeat these False Claims Act allegations. And, that's not an insignificant, if those types of litigations can drag on for years. So I just focus so much on this because it's really critical to understand, even if you end up ultimately not being liable, the amount that it will cost you to go through this process cannot be underestimated. Um, and this is something that is, I mentioned the Department of Justice a few times, and DOJ can certainly pursue this on their own. But the way that the False Claims Act works is that anybody with original knowledge of the false claim can pursue an action against you, and that can include your own employees. That's called key tam. And that happens all the time, where you get a whistleblower who has decided that that's incumbent upon them to pursue this false claim action on behalf of, eventually the government can intervene or not, but they will be able to pursue that. So it's not just a matter of, oh, can I hide this from the government? It's like you've got your own employees that are in the position of being whistleblowers and in fact have an obligation um, to report on this type of false activity, which I'll talk about a little bit more as part of your code of conduct. So definitely understand that this isn't really a theoretical thing. This is something that can come up and has come up for contractors of all shapes and sizes. It comes up in all phases of federal contracting, everything from your proposal submission all the way through your final, your final invoice, all the way through contract performance. Anytime you're dealing with the government, they say, cut square corners when you deal with the government, right? You want to make sure that you're always being forthright and ensuring that you are compliant with all of your contract requirements, lest you end up in this type of a situation. And I've already kind of alluded to this, but let me see, just back up here for a second. So the thing here, the common violation of knowingly presenting or causing to be presented a false or fraudulent claim for payment or approval. When we're talking about knowingly, we're not just talking about like the mustache twirling villain that's like, I'm going to be out here defrauding the government, and they're gonna pay me, and ha ha ha, little do they know I'm giving them hollow chocolate bunnies instead of solid chocolate bunnies. You know what I mean? Like it's not always that blatant. It can be, of course, that's happened, right? It's happened. But a lot of times you'll find yourself in a sticky situation where the contractor has acted in deliberate ignorance of the truth or falsity of the information, or acted in reckless disregard of the truth or falsity of the information. Right. So let's just go back to that example. If you're signing your invoice saying I've complied with all contract requirements, but you don't actually have a compliance program in place to make sure, you've never actually checked your information system to make sure that you're required to now with the assessment requirements, but say that you haven't done that, or you haven't had a contract up to this point that has required that. Have you actually gone and made sure that all of those cybersecurity requirements are being met? If the answer to that is no, if the answer to that is, fingers crossed, I think we're okay, you could have a problem. You could have a real issue there. And, that's why it is critical to make sure that you understand these requirements and that you're compliant with them. Because if and when the government, either through, just general ability to audit your contract compliance, or through the 70/20 assessment, determines that you aren't compliant with the requirements, or you've got an employee who's a whistleblower, and that's what's happening in some cases now. You've got employees who have been working with contractors, and that's what happened in the Aerojet case, which I know I think you have a link to in the link in the slides that I saw at the beginning. I think you have a link to that settlement announcement. But essentially what happened there was that the employee of Aerojet basically blew the whistle, saying, that the company's not complying with these requirements, and they're certifying that they are. Misrepresenting their compliance with their cybersecurity requirements. That ended up in a $9 million settlement, but it got all the way to trial. It settled on the second day of trial. So we never actually, again, settlement doesn't mean liability. In fact, that's kind of the whole point. It doesn't, no admission of liability there, but the fact that they even had to go through that entire process and ultimately still pay $9 million on top of all of the legal fees and all of the headache of having to go through that litigation process for that False Claims Act allegation, in and of itself is a pretty substantial outcome, pretty disruptive at a minimum. And so, something to be aware of as you're thinking about, okay, well, am I compliant with these requirements? I think so. You need to know so, because otherwise that could be construed as, your reckless disregard. You don't have an effective compliance program, which I've kind of mentioned in a few different ways already. To make sure that your employees are understanding what the obligations are and what compliance looks like. Again, I've already covered this, as far as the financial implications. Again, 3 times the damages. It could be reduced to double damages. So yay. If you've got, if you've been prompt about reporting the violation to the government. But that's still going to be a pretty significant amount of money plus your per claim civil penalties. And then just the last thing I'll say about this key tam whistleblower concept, your employees actually have financial incentives to bring these actions, because the private persons who bring these actions get a cut of whatever amount recovered plus their attorney's fees. So, it could be anybody at your company, somebody who's, either disgruntled or recently fired can be a risk of whistleblower activity. So it's not, and I'll put a more positive spin on this here at the end. But the idea here is that compliance is everybody's responsibility, right? It's not it's not just my responsibility as the attorney. It's not just the responsibility of the CEO. Although that's certainly, that needs to be where the tone gets set. But it's everybody's responsibility to verify compliance, to prevent fraud, waste, and abuse. And the government actually incorporates that through the 52203-13 clause, the Contractor Code of Business Ethics and Conduct clause. So that's sort of where these False Claims Act protections are resident in your contract, right? You have a mandatory disclosure obligation to the government if there's any kind of evidence of a violation of federal law, specifically the False Claims Act, right? That's going to be an obligation that proceeds through your entire contract, award, performance, and closeout. It's an ongoing obligation, and it includes mandatory flow down to your affected subcontracts. So I'm just kind of tying it all together. This is a contract requirement in your larger dollar contracts. But certainly, it doesn't mean that if you don't have this clause in your contract, you're not still subject to the False Claims Act. You absolutely are. I bring it up to reinforce the concept that if you don't have a compliance program in place, if you haven't seen or paid attention to this clause before, give me a call and we'll talk about it, and we'll take a look and see what we need to do to get that sorted out. Because as we're thinking about our side, bring it back to cybersecurity, as we're thinking about those requirements and what it is you need to do to comply, to verify to the government, yeah, I've complied with my cybersecurity requirements. What are the consequences of fudging that a little bit? Those can be dire and severe, and not something that you want to have a conversation about with your contracting officer, with the Department of Justice, with the courts. It's a huge existential risk that you don't want to be facing. So again, I just sort of wrap it up here as far as not to forget that there are breach of contract implications here as well. So even if you somehow manage to escape the False Claims Act allegations, non-compliance with cybersecurity requirements or any contract requirements really, you could end up in a default termination, breach of contract, suspension, debarment, significant monetary expenditures, any individual disciplinary actions in your own company, maybe for violating your code of conduct, in that sense. So just all of this is meant to scare you a little bit. I was gonna say it's not meant to scare you, but it really kind of is meant to scare you a little bit, to realize that you have these obligations in your contracts, right? Cybersecurity obligations, they're in your contracts. We could have a whole conversation about this could really apply to any clause that's in your contract that you are required to comply with. But since we're talking about cyber, this is where you want to make sure that you're compliant with all of the requirements. I feel like I've beaten that point now, but it really can't be overstated how critical it is, and what a threat it can be, not only to your financial well-being, but to your ability to continue to enter into contracts with government. If that's your business, if that's, where you want to build those customer relationships, even just the breakdown in trust between you and the government, if you don't, have if there's even a whiff of you haven't been entirely forthright with the government, that can have reputational damage as well. It can go all the way up to going to prison and paying millions of dollars. But even just the relationship impact of not being forthright with the government can have real impacts as you try to continue on this business. So you have the ability to put in place, and the best practice is as far as I'm concerned, from a legal perspective, is to have in place an effective contractor compliance program. You're going to find that it's not always in your contracts, the 52-203-13, but that doesn't mean you shouldn't be following those requirements. It doesn't mean you shouldn't pay attention to them and use them as a best practice to go forward. Because again, even if you're not subject to these awareness and compliance program obligations in your contracts now, as you grow, you might be, number one, and number two, you're still going to be subject to the False Claims Act. That's not going to be something that you're going to be able to get out of at any point. So, this is I've sort of laid out here the elements of an internal control system, which hopefully many of you have. If you don't, I'm happy to talk with anyone offline about what you might need to do to set up a system that allows you to make sure that you're complying with all of your requirements, from a contract perspective, but also how are you encouraging your employees to monitor your compliance. And like I said, compliance is everybody's responsibility. Everybody has to, responsibility has to come from the top down, of course. That has to be the set that culture of ethical behavior, and making sure that everybody's cutting square corners with the government. But, there are certain things that we can do to put in place a compliance structure that's going to help you detect any kind of False Claims Act activity, any kind of deficiencies in your contract compliance, and addressing that before it becomes a significant issue for you. So with that, I've got my contact info here on this slide. I will pause here. I know we wanted to have some time for Q&A session, so I will pause here and see if anybody has any questions.
Kara, we've gotten a question that just popped up here a little while ago. So the essence of it is that how does a contractor get a definitive determination of what level they need to protect themselves to? The context is a government contracting company may have an idea of what level they think they should be, yet the government may have another idea on it. So a contractor may think that they're a level 1, and the government may determine that they really should be a level 2. So how do they get that definitive answer?
I think is that a CMMC question?
It's a CMMC question, but I guess it's a contracting question. Is there some sort of vehicle to be able to say, or anticipated any vehicle to say, hey, your contractor is supposed to be a level 1 versus a level 2?
I mean, I think that's still, and maybe you all could speak to the, where the CMMC process is right now. I think that's going to be something that's identified at a contract level, right? Where they're going to have identified, like, you're a level 1 contract, this needs to be a level 1 contractor, this needs to be a level 2 contractor. I think that's how it's being structured. I know it's been significantly changed. So what that requirement is going to be, if that's the case, when you're in the pre-award process and you see those requirements that are attached to that contract, and really this is true of any questionable requirement that you see in a contract solicitation, engage during the Q&A process, try to clarify with the government what the actual requirement is. And if that doesn't work, there's always the potential for a pre-award protest saying, look, the government has included the wrong requirement in their solicitation, and that solicitation needs to be reformed. You send that up to the GAO, or you can do it a couple of different ways, but usually people go to the GAO and say this needs to be clarified. We've tried to engage the government on the Q&A process. They're not getting it. So we need to have a tribunal intervene and make sure that the correct contract requirement is being included.
Thank you very much for that. There was another question that came up. I'm trying to paraphrase this a little bit. Is so what if you are a sub, right? And you feel that your prime is not following the rules, or maybe one of your staff member is not following the rules. Does QUITAM apply to a subcontractor company?
Sure.
It does. Okay.
Yeah, any private person that has that knowledge of it can make the allegation.
Kara, we have another question about a prime. So if a prime were to ask for the SPURS score, do you have to give it?
I think that is, I don't think you have to. I think that's a conversation you can have with your prime. You definitely have to provide it to the government, and they have to make sure that, the prime has to make sure that the sub is providing it to the government.
How would the prime be able to
verify that?
Yeah.
Asking for the score is one way, honestly, if that's something you're comfortable sharing. You could have them certify that they've submitted it. Just a couple of different ways. When you're in the prime sub area, you're dealing with a bit more of a commercial relationship, so there's a bit more room to negotiate there how you want to share that information, and how it's the give and take, because the subcontractor wants to protect their information, and the prime needs to make sure they're complying with their contract requirements. So there's a bit of a push and pull there, trying to figure out how to make sure that both parties are comfortable with the outcome.
But there's no specific requirement or statement at this point
that the prime must have a copy of the score. I don't believe so. I have to verify that, but I don't believe so.
And then a sub to that, or codicil to that, if I'm a subcontractor and I've made a statement, that I'm compliant to NIST 800-171, and we're found not to be, is there a personal liability for whomever made the statement?
Yeah, there can be. If that's a personal statement that you made to the government, then yeah, there could be potential for personal liability there. It's gonna, they're all very fact specific, but I think if you're in the position of making that certification, you especially want to be sure that you have a good basis for making the statement. You don't want to just sign something that somebody's put in front of you. You want to make sure that they're, and that can be through verifying your compliance system is in place, and that sort of thing, making sure that you've got the right information before making that statement.
And also then we, as an RPO, 3Comply as an RPO, we're asked, well, I'm going to make my attestation. So the new rules under CMMC 2.0 require a quote senior level person makes that attestation. Is that kind of on the same level as making a legal warranty to the government? Like what would that be considered?
I'm not sure I understand the question. Is that?
Well, the question really gets down to, if you put in your attestation, I guess, that you are compliant at level 1, what kind of responsibility? You're a senior official. What are you taking on from a liability perspective?
Yeah, if you're putting your name to something, on behalf of the company, but also as an individual, you're going to want to make sure that you're doing your, the standard here was the reckless disregard for the truth or falsity of the information, right? Or one of the ways that you can look at it. So, again, that's going to be fact specific, but you have an obligation to verify that what you're saying and what you're presenting to the government, especially if it's something that's going to result in a contract award or a payment from the government, is truthful and can be verified. And so that's something that you want to make sure you've set up your own internal. It gets harder when you're a bigger entity and you have more people in play. But when you're a smaller company, it should be a little bit less burdensome to verify that you have those structures in place and that you're complying with all the requirements that you're attesting that you're complying with.
Okay, thank you very much. At the moment, it does not look like we have any other questions.
I just have one quick one,
Oh, please,
Janet.
yeah, go ahead.
Kara, something you said that I've not heard before, when you're looking at proposal submission through contract administration, can you give an example of where the proposal submission could get you in trouble? And who's going to catch that?
Sorry, you say that again?
So in your comments, you said, false claims goes from proposal submission through contract administration.
Okay.
Can you give me an example of like when the proposal submission could cause a problem and who's going to catch that?
Okay. So if you're filling out your representations and certifications, and you're certifying that you have a program in place to comply with whatever requirements are in the contract, I guess one of the ones that's popping into mind, because it just kind of came into final effect, is the covered telecommunications equipment representation, saying I do not use and I will not provide covered telecommunications to the government. If that's untrue and you made that representation and the government said, okay, well, great, now I can award them the contract. But that's not true. You've got Huawei cameras on your building. The government awarded the contract to you on the basis of that false statement would be an example of how that could be, how that could result in False Claims Act liability.
I believe I saw that in SAM.gov registration itself, that particular clause.
Yeah, that's one that just popped to mind. I mean, there's dozens more like that. Yeah. And how that would come, the government doesn't always have the resources or the wherewithal to look under the, I always call it looking under the hood, right? They'll take you at your word. But then maybe you have a whistleblower, or a bid protest is another way. You could have a competitor saying, I see the Huawei cameras on their building, and they'll protest the award based on, the fact that this person shouldn't have. So at a minimum, you might lose the award. At worst you could, and even, and then you could end up further down the road if you find out, well, that was it was a false statement that this contractor made to enter into this contract with the government. Then you're in the position of not only having to pay back all of the money that the government paid you, but then that triple damages, that per invoice, that per claim penalty, all of that can come into play.
So Kara, thank you so much. I think we are at the end here in terms of questions. Nobody else has put any in the chat, but I will remind people, if you do have a specific question, you can put it into the chat, or you have Kara's information right here. And if we are done with questions, then I do think, Bill, you have some more polling stuff, don't you?
Yes, we do. We do have some more polling questions to ask here. I'm gonna steal the screen back.
And while Bill is doing that, I just want to remind everybody that PTACs are a great resource for reiterating any of this information or guiding you to compliance as it becomes effective. So feel free to reach out and find your local PTAC, or you also can reach out to me or us, and I will help you find an appropriate counselor to help you through this.
Okay, so we have some additional polling questions. There's going to be a few different things here. There should be another 5 polling questions that should happen. Hopefully they'll give some insights to the folks on the call. Okay, so Jake, when you're ready. Yeah, okay, great, thank you. So this is the first set. So have you submitted your SPURS score? If yes, do you recall what range the score is? And how confident are you that you can support the SPURS score that you entered? Again, this is anonymous. Okay. If we've gotten some good results, then Jake, if you want to show the results on those ones, and then we're going to ask a few more questions. Okay, so approximately 33% of everyone on the call has sent in SPURS scores to the DoD. 67% had not at this time. So the scores for the most part were between 109 and 50, which with a larger percentage does not know the actual score right now, which is okay. And how confident are you that you could support the SPURS score that you entered? It looks like it's pretty, somewhat evenly distributed between not really and somewhat, and then 22% said very confident, which is all. This is all good information, and we should have another 1 or 2 polling questions as well to pop up, I think. I think we have this one. We have one more, I believe, if I'm not correct. Do you use an attorney to review your government contracts and or agreements with vendors or service providers? So the answers are yes, no, not sure, but probably yes, not sure, but probably no. Give everyone a minute to do that. And when you're ready, Jake, we can show the results. So yes was 22%, no was 56%, not sure but probably yes 11, and not sure but probably no at 11%. So this is also good, insightful information in through here as well. And I think we have one more polling question. So do you have a current security interconnection agreement with your external service providers? So this is something where you have agreements with how you handle security between yourselves and the suppliers or companies that you do business with. Okay, and we are going to oops, sorry. And so we have the answers that came up. 57% is I do not know, and 43% is under discussion. This will come up in later sessions that we come here, but this is good information. Okay. So one item that's as we mentioned, if you want to take a second to, we could also supply this in some of the links in here. This is what was mentioned earlier, which is the False Claims Act suit for Aerojet Rocketdyne. This is a really long URL to copy. We can send this later on, but that also has that information. And this is actually, as you mentioned, Cara had already popped up. This is her email address as well. We can, if you would like to send us or send Cara a request, and we can send, or either one of us, we can send that link to you as well. Okay.
I'm happy to share the slides if anybody has. I know a couple people maybe we're looking for them. I'm happy to share them. If you want to reach out to me via email, I'm happy to send those along.
Thank you very much. Thank you. This has really been fantastic. I appreciate all the good insights and good information that's in here, and also to show that you're a significant resource on this type of thing. So I know people will know how to contact you, which is great. This is just to mention a little plug for what's coming up. We have a day 2 and day 3. So tomorrow we're having Mike Tetro talking from the cybersecurity cybersecurity CISA organization. And also day 3, we're going to be spending all day talking about CMMC. Few different things. If there's any questions, we can, again, if there's any last minute questions, please you can tell us, pop us in the chat, or you can contact us directly at CMMC_help@3comply. Those questions will come directly to us. This is our information from 3comply. So my name is Bill Cameron. We have Anna Cedarquist and Jen Himmelrich. We will provide these slides and these other ways to contact us after a while. And at the end, we are doing some things. Part of the things that we're doing, or again, we're providing these presentations for the next few days. If there's anything that we could help you with, please let us know. We extend some additional services to the PTAC community in general. And we'd love to hear from you to talk more about those. And one thing too is we do have a free set of some free resources that are available that we'll have available to, again, the members of the folks that are participating on the calls. This is a QR code. If you want to just take a picture of it, you just put your name in. This sign up for our email distribution list, but we will send this through and send this to you very shortly. Again, it has a lot of information, some things that you can be able to start doing today, which do not cost anything. We're going to go through these in detail on Thursday's call, but this just gives you, this is a very good resource to be able to start some of your CMMC journey, and you don't have to pay anything for this at all. But anyway, so this is something that's available to you. And we can be able to also provide the link if the QR code isn't working for you as well. And with that, I think we are done. So thank you very much, everybody. Thank you very much, Cara, for all your help and your great information that you provided. And if there are no further questions, I think we can call it a day.
Mhm.
Thanks, everybody. We'll
Thank
see
you,
you
everyone.
tomorrow.
Thank you.
everyone.
Thank you. See you tomorrow.
Who's ever recording can click the button.
Oh, that's me.